Welcome to the We Win Injury Law podcast, everybody. I'm Tyler Todd, your host, sitting here with my co-host, Jaren, the Snow Canyon Man Sandberg.
Good morning.
Good morning. Good morning. Good morning. We're gonna reserve the good afternoons for after we get a little hungry and a little hangry and all those types of things. Then we're gonna give some fine good afternoons.
Well deserved, right?
Yeah,
I'm sure.
Yeah, it'll be well deserved. But thanks for tuning in, everybody. This segment we want to talk about this episode, if you will. People, I know, like when we listen to like a lot of podcasters, I listen to like Theo Vaughn, some personal injury like podcasters. I used to listen to Joe Rogan. I don't know if I like Joe Rogan, to be honest.
It depends. So I kind of am selective which ones I like. So I don't like a lot of the like weird science conspiracy theory stuff, but every once in a while he has like a funny comedian on.
Joe Rogan's legit. I mean, look, Joe Rogan's legit. Don't get me wrong. Obviously. I feel like, hear me out for a second. I feel like he's kind of condescending.
I think it depends on who he's interviewing. Because there's some of them where I feel like he's almost starstruck.
Oh, really?
Yeah.
I don't know. I listened to, and I think Theo Vaughn, maybe not, maybe he's, and I think he'll admit it. Theo Vaughn is not as intelligent as Joe Rogan.
Yeah.
But Theo Vaughn is very like humble and funny, obviously, right? He's a comedian.
And curious. He seems curious about the people he interviews.
And sincerely engaged, like sincerely like and kind and considerate to everyone he's interviewing.
Yeah.
Like even people that are like, I'm like, why are you interviewing this person? I mean, they're like some rando, but like he's like, that's how cool he is. And the few times recently, because I go back and forth, and I'm like, I don't have a ton of time, but when I put him on, I'm like, he just always seems so condescending, like he knows everything, and he's trying to like, I don't know. And then he's like, yeah, you're my good friend, and like everything he said was like negative hating on him. I was like, wait, are you guys friends? Because this is weird. I don't know.
Yeah, it's hard to know. I listen to a lot of like Ezra Klein at the New York Times. I like he's a very left-leaning podcast, but he interviews good people. That's the one that and it's shorter. It's not sometimes like Joe Rogan, I got to be like driving to Provo or driving to Salt Lake. Because this is a long podcast.
A lot of commercials too. Yeah. But anyways, yeah. So what I said was I was going to say was we're not counting our episodes. Yeah. Like this is episode 1052. Yeah. But we want to tell you guys what every client should know, but are never told by their lawyers. Yep. And something we wish everybody would know. Now, in the day and age of ChatGPT and Google, a lot of people do know some of these things. Yeah. Because if you ChatGPT it or Google it, you're going to find it for the most part now. Yeah. But this is something super, super, super important. Okay. Here's some myths. Okay. Number one, your medical treatment determines your case value. To some degree, that's true.
Yeah.
Okay. So a lot of times people think it's the crash that determines case value.
Yeah. The crash was so bad, Tyler. I hear this a lot.
Right. Like we barely survived, or it's a miracle we're alive, or
how's the insurance company look at this? Look at the crash photos. I'm like, that's part of it.
Now, on the flip side, there are many, many times where we look how bad the crash is, and then we look at photos of the crash and we're like, whoa, where were you hit? I don't see.
There might be some license plate scratches.
I don't see the damage. Can you point it out? So the crash in and of itself, no. Okay. What about the story? The story of the crash. Well, of course, to some degree, the story helps because that helps determine liability.
Yeah.
But
the light was red, the light was green. Those things do matter, but they don't impact the value of your case.
The value of your case. What about the pain?
To some degree, subjectively matters.
Yeah, I would say yeah.
But not the ultimate decider.
Well, I would say the story and the pain, like on their face, don't like individually
in isolation,
but together matter.
But do matter
because the pain, obviously, and what you go through, and if it's daily, that's the story. That's what it's hard to convey that, but that's the story that we tell. Yeah. Our client was in pain daily, woke up with pain, went to bed with pain, had to do her daily activities with pain. Many are single mothers. And so they had to do what they had to do as single moms with pain.
Yeah.
And so, yeah, to some degree, it's hard to convey, but it matters as part of the story.
Yeah.
For sure. And then the medical records. Well, yeah.
I think the medical records are the number one, at least is how insurance companies evaluate claims. And the first thing that they care about the very most is always going to be the medical records.
Well, yeah, because medical records substantiate the pain.
Yeah.
Typically, right? And that's why that's kind of the fallacy we're talking about. Because you only have a medical record associated with a treatment that you go and have with the doctor, right?
Yeah.
So you don't go to the doctor every day post accident.
Yeah.
You don't see the doctor every day for your pain. You might go in for your orthopedic visit. You might go in for a chiropractic visit. You might go in for an injection because you're in pain every day, but you only see that doctor once.
Yeah.
So that doctor can only document, okay, patient reports pain every day, maybe, right?
Yeah.
Or patient submit or reports today or is here today with pain.
Yeah. Or I did a deposition recently where our client kept saying 10 out of 10 pain. When I think of 10 out of 10 pain, I think of you hear broken femur, giving birth, right? These
Right.
pain so bad you pass out.
Coming out of your skin.
Yeah, like you need heavy narcotics to
Right.
deal with 10 out of 10 pain. But to this person, subjectively, it's the worst pain they've ever dealt with, right?
Right.
And so I think the defense attorney kept saying, well, 8 out of 10 pain. And so finally I pulled up a pain scale. That was my follow-up in the deposition was, walk me through this pain scale, and I used the one we've used before. I think it's called the Markowski or something pain scale, and she really was in pretty heavy pain. Yeah, ibuprofen, those things don't mask the pain, so it's above a 6. She kind of went through that, and so pain matters. The
Pain
story
matters.
matters. The other things matter, but you telling your doctor also substantiates the story you're telling.
Right.
And I think that's. We've had some clients. We had one just recently. They said, "Hey, I don't want to keep going to the doctor." And I think the message to the doctor was, "They have enough to win my lawsuit." That was and again, I think it was just an educational moment for
Right.
a client that you still have to do treatment that helps substantiate the pain.
Okay, so myth number 2. Well, I don't know if it's a myth, right?
Yeah.
But things that insurance companies are doing to deny coverage, right?
Yeah.
And they do this a lot.
Yeah.
We talked about it briefly. Gaps in treatment, right? So a lot of times, and I had this conversation yesterday with a client. Was it yesterday? Sunday? Anyways, a big thing that people often do is they like, hey, I'm not that, well, I don't think they say I'm not that hurt.
Yeah.
They just say, I can get through it.
Yeah.
Do I really need to go see a doctor? Because I think a lot of people are conscientious of like the financial.
Especially right after an accident, don't you think? Like, I'm going to get better. I've always bounced back from injuries. Right? Like,
Yeah, I think that's what it is. People are like, oh, I can be in pain for a few days. It doesn't warrant like either an ER visit, which is fair, or going to their doctor. Because I think people associate doctor with like dying or like severe pain or severe like disease.
Yeah.
And then of course the financial issue. So then people are like, oh, okay, I think I can like get through this for a few days. Pain will go away and I'll be fine.
Yeah.
But it doesn't go away. But insurance companies will use that against you.
Yeah. And
that's the key.
And what do you think, like, depending on the severity of the accident, the treatment gap also matters. Like, for a small accident, is a 1-month treatment gap really going to hurt someone? Probably not. But a 6-month treatment gap, yeah, it could kill your case. And if you're a juror sitting on it, you're going to say, well, if it was so bad, why'd you wait 6 months? And we've got a couple of cases like this we've done over the years where we had, it seems like it's always younger folks. We've got one gal that just kept pushing through the pain for like 6 months, and finally it took her dad almost, driving her to the doctor.
Right.
And probably has quite a bit of treatment to get her back to feeling pre-accident status.
Well, and everyone has unique, circumstances that dictate whether they can go to the doctor or not.
Yeah.
Right. And that's one thing that you have to remember. Insurance companies and adjusters they're using their own experiences. They're using data. Yeah. But oftentimes adjusters are like, well, I was in a bad accident, so I wasn't that bad.
Yeah.
And I'm like, oh, so that means that this person is faking? Because they didn't have the same experience as you did.
Yeah.
And so they're going to use every type of scenario in a way to minimize, because that's what they do.
Yeah.
So the gap in treatments, they say that you're not hurt.
Yeah.
Or what's another common one?
Well, the gaps are the obvious
Pre-existing
one.
conditions.
They use that one a lot. I had one yesterday. This is my favorite one. I just did an arbitration yesterday morning, and our client got a CT scan, which is on your bones to make sure there's no fracture in the neck, at the hospital day of the accident. Okay, 3 months of treatment, goes 3 months of treatment, and never it just isn't getting better. So finally, the chiropractor orders an MRI. Very different scan than a CT scan. The MRI reveals herniated discs. Now, not all of them were acute, which, not all of them were related to the accident, so she had some pre-existing issues. What was interesting in the closing argument for the defense was, well, the CT scan should have shown all those herniated discs, was his first argument. And I was like, wait, what? So there must have been something in between the 2 months of the accident, which was a serious accident. A Jeep hit into the back of a car, serious accident, pushed him forward quite a bit. So there must have been something that caused the herniated disc in between was the argument. And anyways, it was just one of those, I was just itching to, you want to object in the moment, but I couldn't wait because we get the last say in these arbitrations. But yeah, they'll definitely go after pre-existing conditions, or even try to act like something happened in the middle of the case,
right?
Which was interesting in this situation. They had no evidence. So no evidence there was any intervening fall. There's not like a work comp claim. Some of our clients have other claims out there that insurance companies get on. This one, nothing, no evidence to the contrary.
Yeah, just know that, everybody, that insurance companies will go to all the data and look at all the reported claims that you have in your past to argue whether you've been injured before. So if there's ever a time that you're not telling us, you're not telling your injury lawyer about a claim that you knew was filed a few years ago, just know that the insurance companies know about it.
And they'll subpoena records. So this, I guess, if there's something I wish clients knew, that's definitely one of them, is to tell your attorney if you have any pre-existing issues, because aggravations they still have to compensate you for an aggravation of a pre-existing injury, but if you try to act like there was no pre-existing injury and then they're
going to act like you're just lying and making everything up.
So now you can't. Now you're not trustworthy with anything.
Right. And they may not know the details about the claim, but they know there's a claim, and so they're going to presume that there was an injury. So make sure you tell your attorney everything about it. Last thing probably would be the timeline on injury cases. This is a big question that we get all the time. How long does this take? And the simplest response is, we don't know.
Yeah. Well, and there's some benchmarks in your case. If I were going to say, so once you're done treating for the most of your treatment, we know that there's a window after that we'll negotiate before filing a lawsuit. Right. So we know some of those timelines.
We have an average timeline, and the average timeline of these cases are probably anywhere between 9 to 12 months, sometimes sooner. Whenever we get this asked, I want to say 6 to 12. That varies even. It just depends on you.
Yeah.
And so when I say we don't know, because it depends on you. It depends on the treatment. It depends on the injuries. Depends on how you respond to treatment. Depends on the doctors getting their reports in, documenting the visits. It depends on experts. It depends on whether we have to file a lawsuit, like you just said. Yeah. So there's a lot of question marks and factors that go into how long does this take?
Yeah. Once you finish treatment, we kind of know whether we're going to file a lawsuit within about 3 months. We know that we've sent off a demand about a month and a half in, and if they come back denying the claim, it's real easy to know we're going to move forward with a lawsuit.
Right.
Or we know, hey, they're doing settlement offers and they're getting closer to reasonable numbers. We know we're going to settle your case, but there's even things that happen after we settle the case that we still might have to negotiate with health insurance companies and different things. What I will say is the timeline is we want it to take as long as it can to get you the most amount.
That's it.
And that's really the factor. And so when I see these ads sometimes for like, don't call an injury lawyer, and it's a lead gen company, but it's always, we'll get you the quickest settlement. Whenever I hear quick, I hear you're getting the lowest, or at least you're taking an initial crap offer. We have a case, one I like to highlight that Tyler started with our previous firm even. This is going back 7 years ago. Before filing suit, I think the highest offer was less than $500,000. And it took 4 years of, 30, 40 depositions, expert discovery. We finally got a trial date. I mean, COVID happened.
COVID was in there too,
delayed
so
that. So I don't want to just say that was
for a couple years probably.
But it took a few years. And at the end of that case, the number of the settlement was 4.5 times what the highest pre-trial or pre-filing offer was. So if you're that client and you're going, well, gosh, I could have settled for this, which would have meant she'd have got maybe, I don't know, $180,000 to $200,000 tops to writing a check for millions of dollars. I mean, that's an outcome worth waiting for. And so
and fair. And one time, and I think, and I just had this conversation too, Jaren, insurance companies, and I actually have had it several times over the last few days, they do delay that. I mean, they do what they can to delay and force people into taking less than fair and settling sooner than later because they just not what they want. I mean, yeah, they want, but they need money to pay for ongoing medical care oftentimes, or to at least be compensated for what they came out of pocket for medical treatment they came out of pocket for, or lost wages they suffered during having to go to get medical treatment. So there's a number of reasons that insurance companies will use these delay tactics to just force people into settlement.
Yeah, and not only are they using those tactics, we had recently in Utah, they're hiring lobbyists. They're sending text messages to clients. These guys are doing everything. They're trying to change the laws in the state of Utah. They're doing everything they can to try to minimize your case value.
Right.
The one I saw yesterday that I think you reposted it, but they were trying to call it a new tax on Utahns was the way they were trying to spin that they were lowering case values by sometimes 60-80% on at least what you get reimbursed for medical treatment. So they're going to do a lot of stuff even outside of your case to try to change the laws. There's big pushes in California right now by Uber to go after injury attorneys. So yeah, a lot of things happening for them to minimize your case value. And
they'll do it. And they don't, I mean, unfortunately, not just the at-fault carrier who you may not have any connection to. Oftentimes, though, the at-fault carrier is your own carrier.
Yeah,
they're your own insurance company. And so they do not care about you. And then when you make an underinsured or uninsured motorist claim, meaning that's against your own policy because the other person didn't have insurance or didn't have enough insurance to cover your medical bills and case value, your own insurance company doesn't want to pay you. Yeah. So you're a claim number. They don't care about you. They will do anything they can to minimize and deny your claim. So just know that. We kind of just hit some highlights of some myths and some certain things that we wish everybody would know. But again, that's why, we have jobs, and I saw a stat on ChatGPT the other day. I Googled or ChatGPT'd it. There's like 35. This is just one carrier, and it's a major carrier. Like 35,000 claims a day that they get. That's a lot, and so they don't just write blank checks. They have to defend everything, and they do that. They take all these tactics because if they just paid out every day, they wouldn't
be able to pay their CEO
$30 million a year. Yeah, exactly.
Their shareholders wouldn't get stock buybacks that year. So part of me is like the general concept of insurance we all can get on board with is we all pool premiums. 100 people pool $100 a month in premiums, and when one of us gets in an accident, it pays out. What you don't think about is all the hidden costs of what your premiums are paying, which is massive funding to lobbyists, massive advertising campaigns. I mean, when you think that you're with the best insurance company, look at how good their ads are. That should tell you something of where your premiums are actually going.
Right, exactly.
They're not going to pay out people. They're not going to pay out victims. But gosh, they sure spent a lot of money on the Geico Gecko, right? Or Flo from, right?
Or
Gosh,
Steve from State Farm,
yeah.
or what's his name, and obviously having Patrick Mahomes, and all these star athletes.
Your insurance premium. The one that kills me is that your insurance premiums are paying for that emu. the emu. Like, those are your premiums. Hard at work, guys. Advertising to get more people to buy in.
That's it. So, anyways, you guys, thanks for listening to our rants.
Not biased.
Not biased at all. We're not biased at all. But like, subscribe, share. We appreciate it. Leave early, slow down, be kind and considerate to all those around you. Until next time, everybody.